So the SEBI circular on ODR also provides the framework for empanelment of conciliators and arbitrators by the MIIs. So some basic norms which are provided. One is the case is that there should be adequate number of conciliators and arbitrators commensurate with the number of complaints disputes received. So depending on the number of disputes or complaints which are submitted on the Smart ODR portal and which are referred to arbitrators and conciliators, there has to be sufficient number of conciliators and arbitrators to handle those complaints where they are available and they are assigned. So sufficient number of conciliators and arbitrators are available on the panel of the ODR institutions. Then the conciliators and arbitrators who want to join this particular ODR institution for handling securities market related complaints, instead they may require to undergo training and certification requirements which are stipulated under the circular. Initially, when this Smart ODR was launched, all the existing grievance redressal committee members and arbitrators who were already empaneled with the MIs with the SEBI's approval were eligible to be empaneled on the ODR institution. So this initial conciliators and arbitrators have been already empaneled with the ODR institutions, and currently that those are running live on the ODR institutions panels. Then there is a requirement to have annual evaluation of arbitrators and conciliators, and the ODR institution has to submit a report on their evaluation to the MIIs. The details of the arbitrators and conciliators are required to be published on the website of the ODR institution. Now, this details covers profiles, qualification, relevant experience, number of cases handled, or other points of matters which are available on the ODR institution. This is for the purpose of transparency. Now, one of the things when the empanelment of conciliators and arbitrators by MIs was done, where the MIIs have entered into an agreement with the ODR institutions, where that agreement very clearly identifies the roles and responsibilities of each of the party and the resolution mechanisms in case there is a dispute between an MII and the ODR institute. There is also an agreement between the MIIs and ODR institutions with relation to managing the fees and arbitration fees and the conciliation fees which are collected from the participants and the investors through bank accounts which are opened for the purpose and for disbursal of amounts. So these processes have been completed. Next is coming to the roles and responsibilities of MIIs and the ODRs. There is a requirement to have a MIIs report available for the stakeholders who are involved into the ODS Smart ODR process and who has access to that. So the MIIs and the market participant, they can log in on the Smart ODR portal and generate an MIS report and download it, which shows them the track and timelines of any dispute which are available, and also those reports are available by viewing it on the ODR on the Smart ODR portal. Secondly, any copies of the directions, orders, or the conciliation report which are passed during the pre-conciliation stage, or even the documents which are submitted by the investor or the market participant on the Smart ODR portal or subsequently on the portal of the ODR institution, that is for conciliation arbitration stages also, all those documents and records are required to be maintained for a specific period of time for the compliance with legal requirements under law, and those documents can be available and can be produced to any regulatory authority or a court as and when those are requested for. So the Smart ODR portal is designed and the other ODRs are designed in such a manner that all these documents are maintained and records are maintained for a statutory requirements. Norms for empanelment of ODR institutions by MIs and continuing obligations of ODR institutions. So while engaging or empaneling the ODR institutions, certain norms which were specified, and those are like for any selection of an ODR institution. So those guidelines as per the SEBI circular on the ODR has been abided, and the all the ODR institutions which are part of who are empaneled fulfill those norms and continue to fulfill those. Second is the MI is required to check and monitor the ODR institutions have the capability and ability to integrate their own platforms with the ODR portal. They ensure that the ODR institution and its conciliators and arbitrators abide by the code of conduct. See, so every MI regularly monitors and keeps a check that the code of conduct specified by SEBI is also followed by the ODR and the conciliators arbitrator while conducting the arbitration conciliation proceedings. The ODR institutions who are empaneled, they have to cater to certain roles and responsibility in the ODR ecosystem. They need to form a association or become a member of the association. Uh, they will need to also, the ODR institution has to examine the complaints in case they are received against their conciliators and arbitrators, and then review them and report the findings, outcomes, or actions against those considered arbiters to the MIIs. There could be a possibility that the conciliator and arbitrator and the parties who are before those conciliators arbitrators may have some complaint against them. Those complaints can be filed with the ODR institution, and the ODR institution will take cognizance of it and review them. The ODR institution is also required to abide by the norms of transparency laid down by the MIs and SEBI. They should update their portal with the results of ongoing proceedings of conciliation and arbitration. So, any conciliation and arbitration proceedings which are ongoing, the status and the progress of that is available on the ODR website, on the ODR's website, uh, such that the any party who is part of that matter can log in and check the status of them. They will also, ODR institution will also require to fulfill the audit requirements. Their platform and the processes of will be may go undergo audit, and they should fulfill that. The ODR institution should also have adequate infrastructure, manpower, and resources to handle the number of complaints, number of matters which are assigned to them through the Smart ODR portal by the MIIs. For the purpose of empaneling conciliators and arbitrators on the ODR institutions, SEBI circular has suggested certain norms which these conciliators and arbitrators should fulfill. However, these are suggested norms and not a completely mandatory norms. So the norms which are here is like age. The conciliator arbitrator should be between 35 to 75 years. The qualification norms, like the person has a qualification of law or finance, including securities market, accounts, economics, technology, management, or administration. The person should also have a minimum 7 years of experience in certain sectors like financial sector, banks, NBFCs, MIIs, or other intermediaries of the securities market. The person has worked in legal services, and such legal services could be certified professionals in conciliation, handling conciliation and arbitrations independently, or certain other legal services. Ex officials from the Indian financial regulators like IRDA, PFRDA, RBI, and SEBI. So, a person having experience in these fields of minimum 7 years would be suitable for getting empaneled on the conciliators in a parliament or conciliator and arbitrators. There are further norms like knowledge and knowledge skills. Now, knowledge could be in relation to functioning of the securities market, securities laws, arbitration and conciliators in India. The person is expected to be familiar with these areas. He should be proficient in English language and one or two regional languages, reading, writing for effective dispute resolution. There is a requirement that the conciliator and arbitrator should understand and able to communicate with the parties, especially investors where they are not proficient in English and they like to discuss and debate matter in local regional languages like Hindi or Marathi or Gujarati or other Indian languages. So having an additional proficiency in other languages would be a benefit for the conciliator and arbitrator. The conciliator arbitrator should be also good in legal drafting and communication skills. He should also have good decision making skills. The other criteria are like financial integrity and good reputation honesty. So this ensures that the person remains independent and is of sound reputation. He should not be convicted by a court of any offense involving moral turpitude, economic offense, or offense against the securities laws. The person should not be an insolvent. No order restraining, prohibiting, or debarring the person from dealing in securities or from assessing the securities market has been passed by SEBI or any other regulatory authority. The person should be of sound mind. A person should be also financially sound and not a willful defaulter. So these are the certain criterias which the conciliator and arbitrator has to maintain to ensure that he is independent and also he has sufficient capacity and capability to handle conciliation or arbitration matters.